We were at B. The agency may require that such amount be paid into the Treasury of the United States, or except where such disclosure error resulted from a willful violation, was intended to mislead the person to whom credit was extended. In the case of an open-end credit plan more than 2 years after the violation, or in the case of any other extension of credit as follows. With respect to creditors that are subject to examination by the agencies referred to in paragraph 1 through 3 of subsection A of this section, except in connection with violations arising from practices identified in the current examination, and only in connections with transactions that are consummated after the date of the immediately preceding examination. Except that where practices giving rise to violations identified in earlier examinations have not been corrected, adjustments for those violations shall be required in connection with transactions consummated after the date of examination, in which such parties were first identified. 2. With respect to creditors that are not subject to examination by such agencies, except in connection with transactions that are consummated after May 10, 1978, and in no event after the later of the 1. Expiration of the life of the credit extension, or 2 years after the agreement to extend credit was consummated. Number 4, notwithstanding any other provision of this section, an adjustment under this subsection may be required by an agency referred to in subsection A or C only by an order issued in accordance with cease and desist procedures provided by the provision of law referred to in such sections. B. In case of an agency which is not authorized to conduct cease and desist proceedings, such an order may be issued after an agency hearing on the record conducted at least 30 but not more than 60 days after notice of the alleged violation is served on the creditor. Such a hearing shall be deemed to be a hearing which is subject to the provisions of Section 8H of the Federal Deposit Insurance Act 12 USC 1818H, and shall be subject to judicial review as provided therein. Except as otherwise specifically provided in this subsection, and notwithstanding any provision of law referred to in subsection A or C, no agency referred to in subsection A or C may require a creditor to make dollar adjustments for errors in any requirements under this subchapter, except with regard to the requirements of section 1666D of this title. Number 6, a creditor shall not be subject to an order to make an adjustment if within 60 days after discovering a disclosure error, whether pursuant to final written examination report or through the creditor's own procedures, the creditor notifies the person concerned of the error and adjusts the account so as to assure that such person will not be required to pay a finance charge in excess of the finance charge actually disclosed, or the dollar equivalent of the annual percentage rate actually disclosed, whichever is lower. Okay. Notwithstanding the second sentence of subsection E1, subsection E3CI, little I, and subsection E3C, two little i's, each agency referred to as subsection A or C, each agency referred to in subsection A or C shall require an adjustment for an annual percentage rate disclosure error that exceeds a tolerance of 1/4% less than the actual rate, determined without regard to section 1606C of this title with respect to any transaction consummated between January 1st, 1977 and March 31st, 1980.